I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Blues. Welcome back, everyone. I'm Alice, and I'm joined, as always, by my indispensable host, Brett.
Hi, Alice. I feel pretty dispensable right now, I gotta say.
You poor thing. Okay, before anyone writes a review saying how Brett sounds completely stuffed up or nasally, he is so sick, and he crawls out of bed to record tonight because we promised you guys these current events or weekly podcasts, and they take a lot of time to put together. So you can't really have sick days when you have a weekly episode.
And I know this is beginning to sound like a broken record because it seems like I'm sick all the time. I am sick all the time lately. It's just the truth. So we're just
really
pushing through.
I don't know what's happening to you. I really hope you're okay, but I knew you for like half a decade before this, and you were never sick a day in your life. And then this year, I think you've been sick just nonstop, and I'm sorry about that.
Well, you know, it's just a sick time, so I guess we're just all going to have to muddle through as best we can. But we're here, and we're excited to finally leave controversial things behind. We've been talking about controversial Supreme Court cases and talk about something that's not controversial at all, the West Memphis 3 case.
And now you guys understand why Brett left his sick bed to record this, because we are talking about West Memphis 3, finally.
Finally. Really, one of the cases that got me into true crime in a lot of ways. I think a lot of people watching Paradise Lost was your introduction to true crime. I mean, this is a case that happened all the way back in 1993 when a lot of you weren't even born, but those of you who are old like me, you were, you know, in your teenage years, you were rebelling, you were listening to Metallica, maybe you were wearing black, and you really, when you saw this story and when you saw this documentary, you connected with the West Memphis 3 in a way that was really different from anything before. It was a unique documentary, and I really think is the beginning of modern true crime. For those of you who don't know, the West Memphis 3 are 3 teenagers at the time in 1993, Damian Eccles, Jesse Miskelly Jr., and Jason Baldwin, who were accused of brutally murdering 3 other young boys, 3 8-year-olds, as a matter of fact, Stevie Branch, Michael Moore, and Christopher Byers. This happened in the town of West Memphis, Arkansas, a place where a traditional sort of southern town in the 90s, kind of lower middle class, down on its luck to a certain extent, very religious. And these 3 boys were viewed as outcasts and outsiders because they did things like listen to Metallica. And Jason was best friends with Damian Eccles, who was into esoteric things and what some people might call satanic things. And this was at the sort of tail end of the satanic panic. And so this became this cult-based, heavy metal-based murder where these 3 teenagers had murdered these 3 boys in this sort of occult ritual. And it became a cause celeb. And for all 3 boys, all 3 teenagers were convicted of the murders, sentenced to life in prison. Damian Eccles was sentenced to death. But for years, people fought for their freedom, claimed that they were wrongly convicted. And then in 2011, after some victories in the appellate courts, the 3, Eccles, Baldwin, and Miskelly, agreed to enter into an Alfred plea, plead guilty, but be released from prison, no longer on the death penalty, no longer life in prison. They would get time served, and they would be freed. We've talked about Alfred pleas before. Essentially, you are pleading guilty while maintaining your innocence, but acknowledging that the state has enough evidence to convict you. And in the years that have passed, the over a decade that have passed, people remain divided on whether or not they're innocent or guilty. And Eccles in particular has been very aggressive in attempting to test new evidence in an effort to prove once and for all that the West Memphis Three are innocent of this crime.
So the West Memphis Three sought relief under Arkansas Code Section 16-112-202. Now, this section falls under Chapter 112 of the Arkansas Code. That may sound like a lot of gobbledygook, but what that is habeas corpus. Now, this will become very important in the final decision of the court. We've talked about habeas before, but specifically habeas under statute section 16-112-103 reads, "The writ of habeas corpus shall be granted forthwith by any of the officers enumerated in section 16-112-102A to any person who shall apply for the writ by petition showing, by affidavit or other evidence, probable cause to believe he or she is detained without lawful authority, is imprisoned when by law he or she is entitled to bail, or who has alleged actual innocence of the offense or offenses for which the person was convicted." It goes on to say that, quote, "The procedures for persons who allege actual innocence shall be in accordance with section 16-112-202 at sec." Section 201 is the new scientific evidence portion of habeas, and it leads into the DNA testing section, sometimes called Act 1780 of 2001, or Section 202.
Yeah, so basically you have the situation where Damien in particular, we say the West Memphis Three, but it's really Damien. He wants to test this evidence. He basically says, look, there's all this evidence that's been sitting in a locker somewhere. We got this new DNA technology. It's MVAC, which a lot of you have heard about. We want to use that on the evidence. We want to suck up all the DNA. We want to test it. And who knows, maybe we'll get a DNA hit and we'll finally know who really committed these crimes. And so he and his lawyers get together and they file this action. And they file it under this sort of statutory structure that governs when you can do this DNA testing. And just to break it down for you, let's go back to section 103. So 112 is the habeas chapter in the Arkansas Code. So if you want to read all about habeas in Arkansas, you go to section 16-112. And in that, you have sort of three ways you can seek this relief. One is if you show probable cause to believe that he or she is detained without lawful authority. What does that mean? Detained without lawful authority, we've talked about this before when we talked about ineffective assistance of counsel. So basically what you're saying in your habeas petition is, I am in prison, I have been convicted unlawfully because I was denied my right to counsel. My counsel was ineffective, therefore I did not have constitutional counsel, therefore I am in prison without lawful authority. Now this is different from saying you are actually innocent, because just because you're actually innocent does not mean that you are detained without lawful authority. If you are tried and convicted and you have a great lawyer and the judge makes all the right decisions and there are no mistakes and it's the perfect trial and you just lose because the jury finds you guilty, you are lawfully imprisoned. You may be innocent, but you're lawfully imprisoned. So you have this third section. We'll skip the second section because it's just, I'm entitled to bail and didn't get it. It's kind of boring. The third section, who has alleged actual innocence of the offense or offenses. So if you're claiming you're actually innocent, you fall under that third category. And then that gets you into 201 and 202. But it's important, both 201 and 202 are still under Chapter 112, which is the habeas chapter. And we're going to talk about why that's so important. The first thing to know is that the state opposed this motion. That was not necessarily sure going in. If you guys listen to Bob Ruff, he's very close to the West Memphis Three. He's talked a lot about this case. He was sort of under the impression that it was a 50-50 proposition, that the state might just go along with it. The state would eventually say in their filing that they couldn't just go along with it. And we will post, by the way, the filings of Damien, the state, the reply to Damien, and the final ruling of the court on our website if you want to read those. But the state said a couple things. Number one, they said we can't just go along with it because in our view, a court has to order this kind of testing under this statute. Is that right? Is it not? I don't know. A lot of times prosecutors can test evidence without a court order. This is DNA. There's a DNA statute. I can sort of see where they're coming from. I don't know if they're right or not, but that was their position. We can't just do it. We need a court order. But they nevertheless opposed doing it, and they pointed out several reasons why. The first thing is they argued that the petition had been filed in the wrong court because it wasn't the court of conviction. This actually seems like it may or may not be true. This is sort of a tricky thing because the West Memphis Three were convicted in one county. That conviction was dissolved, and they entered into the Alfred plea in a different county. So it's a little unclear which county they should be filing in. But in any event, the district court didn't worry about that. So that argument failed. The second thing they argued is that you can't have habeas relief when you aren't in custody. We're going to talk a lot about that today. The third thing was they said you can't use the MVAC because they said it violated state law. Under state law, they are required to preserve all the evidence, and the MVAC necessarily destroys evidence, was what they said. People argue about this a little bit. I've heard Bob say that the MVAC actually is the best thing to do if you're doing DNA because it preserves 9/10 of the DNA when you suck it up with the MVAC. Well, the problem is, and I think what Arkansas is saying, is once you use the MVAC, that's all the DNA you're ever going to get off that piece of evidence. If one day MVAC .2 comes out and is way better at getting DNA evidence and would get even more DNA evidence off of whatever you're testing, well, it's too late. Once you've used MVAC 1, it's gone. Whatever you got is all you're ever going to have. So I think that was one argument they were making, and they wanted to have some sort of evidentiary hearing on that and argue about it, which is common in things like this. They also raised some interesting due process concerns. So only Damian Eccles had made this motion. Jesse Miskelly and Jason Baldwin had no say in it. They were not part of this, at least not officially. Jason more or less said he generally agreed with it, but I don't think we've heard from Miskelly. And the problem is, if this is going to destroy evidence, they have an interest in that and they should be heard. So that was another thing the state was arguing. And they made a timeliness claim, which you're always going to make, which also probably was going to fail. But those are sort of the big points that the state made in opposing this motion.
So now that the court has Damian's motion for relief and then the state's opposition, the court then rules. And the ruling is this, quote, "Our General Assembly did not make scientific testing based on new technology an independent form of post-conviction relief. Instead, the legislature amended statutory law to make scientific testing based on new technology a form of habeas corpus relief. In order to get habeas relief, one has to be in custody. Custody ordinarily means prison, but it can also mean supervised release, probation, parole, etc. But once the state is no longer actively controlling your life, you are not in custody. The fact of a conviction and the attendant limitations on life, such as owning a firearm, voting, etc., is not custody."
And so this was a source of a lot of controversy and confusion by people who watched this, because in other states, this is not necessarily true. Remember, we've said this before. We got 50 states with 50 different rules. The federal rule is this one. If you're not in custody, you can't get habeas. And we're going to talk about why in a second. The states are kind of different. I know, for instance, that Washington State has a habeas provision that allows you to seek relief even when you're not in custody. Arkansas doesn't have that. Arkansas has the more traditional habeas that says you have to be in custody. And so essentially what the court is saying is, look, when you took that Alfred plea, you kind of made a trade-off. You said you were guilty, you got out of jail. Well, now you can't bring habeas. I mean, that's a pretty rough thing to say. Like, if you wanted to challenge this, you should have stayed in prison. But the legislature, when they added this testing, as we talked about earlier, they put it in the habeas provision. Now, why is that important? So habeas corpus is a medieval Latin term that basically means we command you to bring the body of the person before us. That's essentially what it means. It's been called by some people the ancient writ. You probably all heard of the Magna Carta, which was the Charter of Liberties published in England in 1215. And it's often thought of as the basis for our conception of freedom and individual rights in the Western world. Well, the writ of habeas corpus is even older than that. It goes we're not exactly sure how far back it goes, but we know that the first written example of it that we have comes from something called the Assisi of Clarendon of 1166, which stated, "No free man shall be taken or imprisoned, or be disseized of his freehold, or liberties, or free customs, or be outlawed, or exiled, or any otherwise destroyed, nor will we not pass upon him, nor condemn him, but by lawful judgment of his peers, or by the law of the land." So, if you're one of these people and you're having these liberties taken away from you, or you're being outlawed, or you're being exiled, you can appeal to the peers of the land and say, "This thing is being done to me, but you haven't passed judgment upon me, so I deserve my day in court." And he could get it because of this promise that was made to sort of all free men. And this is included in the Magna Carta. What's interesting and sort of way ahead of its time, the Assize of 1166 is about free men. The Magna Carta actually says no one. So no person, regardless of who you are, what your status is, could have their liberty taken away from them without having the right to demand to be brought in front of a court and have their day, as it were. And that is the heart of habeas corpus. But the problem is you have to be in custody in order to get habeas corpus. And there's Arkansas Supreme Court precedent directly on point. There's a case called Anderson v. State. And it, much like this case, is an actual innocence case. So in Anderson saying, "I am actually innocent. I want a habeas petition. I want to have my day in court." And this is what the Arkansas Supreme Court said about that in 2003, which once again postdates this DNA statute, which passed in 2001. Likewise, appellants request that a writ of habeas corpus be issued on the basis that he is actually innocent of the offense of which he was convicted in 1992 was also moot. As stated, appellant was not incarcerated as a result of the 1992 judgment. Therefore, a writ of habeas corpus could not be issued to obtain his release from custody arising from the judgment. An issue is moot when any judgment rendered would have no practical legal effect upon an existing legal controversy.
And that might seem harsh, but you can imagine why that would be the case, right? You can't go to the court and ask for an advisory opinion. Of course, that's not what Damien is asking for here, but an advisory opinion means there's no case in controversy and there's no relief the court can be granted. So, the court is not just there to hear your arguments if they can do nothing about it. The court is in its power to be able to do something, but when the condition precedent does not exist, and the condition precedent being in custody, then there is no relief that can be ordered from a motion under habeas corpus.
And I think people think of courts as just these roving power units, and they can just do whatever they want, whenever they want, wherever they want. But that is not true. Courts are limited in their jurisdiction, both over space, so what area they can rule over, and the extent of their power. And if they are not given power, they can't do something. So their power in habeas is a pretty big deal, that you can say to the state, "Bring me this person that you're holding and tell me why you're holding them." That's a big deal. That's a big power, but that is a limited power. It's limited to the circumstances in which the legislature has given them the power to do that thing. And it is limited here in Arkansas to prisoners who are in custody. And if they're not in custody, then the court doesn't have jurisdiction over that person. They can't just sort of freewheeling order things. And that's why when you read the judgment, Alice read it earlier, she says essentially that the Arkansas legislature did not make scientific testing based on new technology an independent form of post-conviction relief. They did not create a vehicle, an independent vehicle, to seek this kind of relief outside of habeas. They put it in habeas. And by doing that, they put the limitations of habeas on this form of relief, and that means you have to be in custody.
And so you might be thinking, if this is such an established issue, why could the West Memphis 3 attorneys file such a motion when they know that there simply wasn't any relief the court could grant? Well, I think the attorneys must have known this. And so in their initial motion, if you read it closely, they studiously avoid citing to any statute regarding the testing of evidence. Perhaps they thought that the state just wouldn't oppose and they could kind of slide by with basically calling it what it was. But the state, of course, did oppose and making all the habeas arguments you would expect and that they should have. And in their response, the West Memphis 3 argued that the habeas statute should be read to apply to the many other consequences of conviction other than incarceration. They also argued that the legislature had intended the habeas relief for DNA to be broader than standard habeas relief. So in other words, they kind of avoided making this argument at all in their opening brief, but when the state kind of didn't take the bait, so to speak, they saw it for what it was, which was habeas relief, and argued against it. Then in reply, the West Memphis 3 kind of created this new argument as to the statute should be read differently, kind of recognizing that the statute doesn't cover the situation.
And look, that's not a terrible argument.
No, not at all.
You could see that succeeding. I mean, you could say, look, clearly the legislature wanted this evidence tested. They created this whole way to do it. Yeah, they put it in the habeas section, but nevertheless, it should be broader. You could see that. And who knows? I mean, maybe one day they'll take this all the way to the Arkansas Supreme Court, and the Arkansas Supreme Court will say, yeah, you know what? We think the legislature did intend this to be broader. But based on what we have in front of us, it's hard to see that succeeding.
That's right. Now, the problem for the West Memphis 3 is that this clearly is a habeas petition, as they even recognize in their reply. Now, this is true for a couple reasons. First, this is in the habeas section of the statute. And when doing statutory interpretation, courts will often look to where the language is located within the statute. Moreover, the Arkansas Supreme Court has all but said it is a form of habeas relief. In Hess versus State, a Arkansas Supreme Court case, the court said, quote, Act 1780 provides that a writ of habeas corpus can issue based upon new scientific evidence proving a person actually innocent of the offense or offenses for which he or she was convicted. And in fact, the Hess court cited Damien's case, Eccles versus State, which came out in 2002, in support of that proposition.
So this couldn't have come as a surprise to Damien's team. It seems like they were surprised, but you have all this case law that says, look, this is a habeas petition, and this is when the writ of habeas corpus will issue. And how do we know that? Well, here's the Eccles case from back in 2002, which Damien brought immediately after this statute was passed, when he was incarcerated, and therefore would have been able to bring this kind of challenge. I'm not sure exactly what happened with it. Sort of bounced back and forth. It might have been one of the things actually that led to their eventual release in 2011. But in any event, it didn't lead to the kind of scientific testing that's available now. So they want to sort of do it again. And this time they want to use the MVAC. And because the MVAC is new, they can do it again. I mean, the statute's pretty clear. When you got new technology, you can do it again, which is why the timeliness argument of the state's not going to work. But the habeas problem is really difficult to get over, and it's the reason that Damien's lawyers' arguments didn't succeed. And you kind of feel like if this evidence is going to be tested, they probably do need new statutory authority to do it. They probably need a new statute that creates an independent vehicle where you can test evidence in cases of actual innocence claims, even for people who have been released. I don't think that would be the worst thing in the world. I think that's probably pretty good. You could put some safeguards on it to make sure it's not happening all the time and it's not wasting state resources. But when you have a case like this and you've got evidence and there's a possibility to test it, you would at least like the judge to be able to consider it. In this case, the judge has a hearing, everybody shows up. You guys know how the West Memphis 3 case is. There's like 1,000 people outside the courthouse who can't get in because they got COVID protocols going on. I think Bob got COVID while he was there, which is unfortunate. But they're going to have this hearing and it lasts for 30 minutes because the judge gets up and says, sorry guys, I don't have jurisdiction. You've brought a habeas claim and nobody's in jail. Nobody's in custody. Where am I going to bring the body from? Right? I mean, that's sort of the problem. And so she doesn't get to any of those interesting questions about can you use the MVAC or does it destroy the evidence or all that sort of juicy stuff that you would like to see. She never has an opportunity to do that. So yes, I think they're probably going to have to seek some sort of independent remedy from the legislature. Now, we can get nerdy on this though, because there is another vehicle called a petition for writ of quorum nobis, which is even wonkier than a habeas petition. And I have had one case with the quorum nobis. Actually, I have a habeas story I want to tell, which is kind of funny. So,
of course you would have a habeas story.
about like, I was in jail, and anyway, so I don't know how long ago it was, 5 years or so. I got this case, and the guy who gave it to me was like, I hate to do this to you. Everybody hates this case. It's been going on forever. We got this guy. He's super litigious. He's out on supervised release. He's not even in prison, but he keeps filing these habeas petitions, and he's always coming up with new reasons, and so we always have to reply to him. And so you've drawn the unlucky straw this time. So you have to respond to this habeas petition. And I started thinking about it, and I was like, well, he's on supervised release. We don't really even care about this guy. So I wrote the brief, and so I wrote all the reasons that the judge should deny this guy's habeas petition. But in the end, I was like, or the judge could just release this person from supervised release, which would moot this appeal and foreclose all future habeas petitions because he would no longer be in custody. And wouldn't you know it, that's exactly what the judge did. The judge ended the supervised release, and this guy couldn't file his habeas petitions anymore because he wasn't in custody, which was nice. I felt very vindicated.
That was awesome. That was some creative thinking on your part.
Yeah, what can I say? I also have done a quorum nobis case before. And the thing about quorum nobis is it really is kind of about this sort of thing. It's a vehicle for when you claim you're innocent, even though you aren't in custody. And it gives you sort of this ability to challenge that. Wikipedia has a handy definition, so I'll read it to you. Legal order allowing a court to correct its original judgment upon discovery of a fundamental error that did not appear in the records of the original judgment's proceedings and would have prevented the judgment from being pronounced. Now, different states, different jurisdictions have different views of how broad quorum nobis can be. A lot of actual innocence cases come through this. Might be difficult to do in Arkansas because, once again, the statute is in the habeas section, so I don't know if it would work. Also, the Arkansas Supreme Court, while they allow the writ, it kind of narrowly allowed it. And they basically said there are 4 circumstances in which you can bring it: insanity at the time of trial, a coerced guilty plea, material evidence withheld by the prosecutor, or a third-party confession to the crime during the time between conviction and appeal. So the avenue might be foreclosed, but I think you could argue that the new DNA evidence is kind of like the third-party confession, because it's basically proof that you didn't do it after you were convicted, but before your quorum nobis appeal. So who knows? I mean, maybe you could do that. I don't know. I think the best bet is to try and get some new legal avenue. And I think until that happens, I do not anticipate that they will be successful here. Though, like I said, you never know. They might go to the Arkansas Supreme Court, and the Arkansas Supreme Court might say, you're right, this is broader than habeas. You don't have to be in custody. Voila. And then they can go back to the Arkansas court and litigate this case. But we'll just have to see, and we will follow it and keep you guys up to date on any developments.
Brett, I'm so glad that you're our habeas expert, because habeas is that subject in law school that most people run screaming from because it is so convoluted, and there's just, habeas petitions that you receive mostly are handwritten by inmates, and we, of course, have to respond to them, but it can be very difficult to, literally read handwriting. I think all of us have kind of forgotten how to write by hand, and so it's difficult to decipher, and even more difficult sometimes to decipher these creative arguments that are brought, and they truly are creative. Because of that, there are so many interesting cases that come out of these interesting fact patterns, and I think what you can get from this is, even though when this motion was filed by Damian Eccles, it caused, massive waves through the true crime world and the West Memphis 3 true crime community, but really it was a very boring non-issue, kind of resolved on a technicality, because none of the substantive issues the true crime community wanted to talk about could even be addressed by the court. And that's because, what we've already said, the court is one of limited jurisdiction and one with limited powers that is only deciphering what the law before them reads. They don't create the law, and they do not change the law. They just interpret the law as written by the legislature. So while a lot of people may be excitedly following the legal proceedings, oftentimes this is going to be the result, kind of a technicality, boring response, which is not necessarily wrong, because like we said, the fix here would probably be a new legislative avenue written by people who are voted on by the people of Arkansas. So I don't know that this is exactly what you all expected from our West Memphis 3 episode, but I think it's very helpful to kind of read through the headlines here and know what was actually happening in this case and what was not happening in this case as well, to really understand what's going on in the legal proceedings.
Yeah, I mean, the whole point of this show is so that everybody can understand these things when they happen. Because we see all the confusion in the gallery and everywhere else when you have these really, I mean, habeas corpus, like I said, it's medieval Latin. It's really complicated. Like Alice said, the class you take on habeas corpus in law school is the one everyone hates the most. I went to exactly one class of that class. I don't know if I've told you this story. I'd gotten really into Guitar Hero, and there was this one song I really wanted to beat, and so I was totally committed to beating that song. And so the only class I went to I was on call, so I had to go to that one. So I went to that class, and that was it. But obviously, I still did okay in the class. But it's just boring, terrible stuff that everybody hates, and we just want to make it more accessible to you guys, so that when you hear these stories, you have some understanding of what exactly is going on.
Indeed. So, as always, let us know what you think. If you have any more questions about habeas corpus, maybe, we don't know. We'll cover West Memphis 3 in our other podcast, The Prosecutors, maybe at some point. But this is what we have today for the Prosecutors' legal briefs. Before we sign off, Brett, do you have anything else to add?
I don't think so. It's a pleasure as always, Alice. Hopefully I'll make it to the next episode.
I really hope you're going to be okay, but thank you for getting out of bed and grabbing your Kleenexes and recording tonight, because it's always a pleasure talking with you, especially about habeas corpus. Well, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors' Legal Briefs.
And there's been a lot of... What was that? Sorry.
I said you're going to make it.
I'm doing the best I can.
No, you're doing so good. The fix here would probably be a new legislative avenue written by people who are voted on by the people of Tennessee.
Arkansas.
Oh my God.
Well, Memphis is in Tennessee, it's like,
but I've been reading about Arkansas cases this whole time, so, maybe you're not the only one sick.
It's okay. I forgive you.